Wakili, thank you for having us at your place within this short period of time, and welcome for our short or brief interview. Wakili, you understand we are having a by-election in Malava, Kakamega County, slated for 27th November 2025. And we are having one of the contestants, or now a candidate, who is vying for that seat, but he is also a sitting member of County Assembly of Kakamega. And there is a raging debate on whether Honorable Ndakwa should resign or not within 7 days of declaration of vacancy. Maybe as a learned friend, as a lawyer, under Elections Act 43(6). What does it say about such scenario?
Thank you very much. Of course, under the Elections Act and our legal parameters, it is evident that a member of County Assembly who is sitting is a state officer, so defined, and then he ought to resign within 7 days after their party primaries and on nominations. However, opinion is divided on this particular subject matter. Opinion is divided because the section that I've just mentioned speaks to the effect that a sitting member of County Assembly is ineligible to contest and run to become member of National Assembly without resigning within 7 days of the nomination. Of course, Article 260 of the Constitution speaks about who a state officer is and who a public officer is. It is not in dispute that the Honorable Ndakwa, being an MCA, is a state officer, because as the Supreme Court has previously said in the Outa case, if your salary or pay either comes from the consolidated fund or is appropriated by Parliament, then you qualify to be called a state or public officer. However, there is a decision that Honorable Ndakwa is hanging on, the decision of the Court of Appeal in Wanjiku Kibe Court case, the Gatundu North Member of Parliament, who was a sitting member of National Assembly or member of County Assembly. She never resigned, and when she was elected, not having resigned, her challenger successfully went to the High Court, and the High Court nullified her election as Member of Parliament for Gatundu North. However, the Honorable Wanjiku Kibe got reprieve from the Court of Appeal when the Court of Appeal said that it was not necessary for the member of the County Assembly to resign before contesting as a member of the National Assembly. That decision may give the Honorable Ndakwa a lifeline, even though he never resigned, because now the level we'll go to will be to ask between the provisions of Section 43 of the Elections Act and the decision emanating from our courts, what lawyers call jurisprudence from the superior courts, which one is more superior? And going by practice in our legal field is that once a superior court, like a Court of Appeal, has made a declaration that the member of the County Assembly need not to resign, then that becomes law. And it means that effectively that decision of the Court of Appeal reverses all the policies in place, reverses what the statute says about resignation. And that is why Ndakwa could be sitting pretty, knowing that he has reprieve in the decision of the Court of Appeal in the Honorable Wanjiku Kibe case.
Maybe in our interrogation we have found that Ndakwa is still a sitting member of, or an MCA for Kabaras West, and this means is continuing, is representing his people at the same time receiving salary. Maybe when and at what point should Ndakwa cease to be an MCA?
First, we agree that going by the strict letter and the spirit of the statute, Ndakwa is ineligible to run as member of the National Assembly for Malava constituency. But going by jurisprudence or other decided cases from the courts, Ndakwa is eligible because his predecessors, like the Honorable Wanjiku Kibe of Gatundu North, have contested for elections without resigning, and the Court of Appeal has upheld their decision not to resign. The reasoning of the Court of Appeal is this, that member of a county assembly is a representative seat. Since it is a representative seat, it does not or should not be vacant. So you're not required to resign so that there is a vacancy and people are not represented in the guise that you're going for another seat. And therefore, if the Honorable Ndakwa wins this election, and so help him God, if he wins or if he loses, I neither belong to his party nor do I support his bid. If he wins this election, on the day of his swearing in as Member of Parliament for Malava, he will cease being MCA for Kabras West. That time, that moment in time will then lead to the declaration of a vacancy in the seat of MCA Kabras West. That is why the Speaker of the County Assembly of Kakamega has not been keen to declare that that particular seat held by Ndakwa is vacant. You see, if Ndakwa had resigned, even the clearest test will not be the payslip. The clearest test will be a notice to the Speaker of the County Assembly, and the Speaker of the County Assembly is under a legal obligation that once he has been notified by a sitting MCA, he proceeds and declares that particular seat vacant and notifies IEBC so that a by-election process can start. Now that the Speaker has not declared that particular seat vacant, then effectively, the Honorable Ndakwa has not resigned. And it's going to be a legal tussle whether Ndakwa wins or not, because should Ndakwa win, people will go to court and say they want to contradistinguish between the Wanjiku Kibe case and the Ndakwa case. The Wanjiku Kibe case related to a general election, and the court was protecting the fact that MCAs are elected for a term of 5 years, and therefore to require them to resign before their term ends will be to treat them differently. You know, like Parliament today, members of Parliament effectively lose their seats on the election day, the morning of the election day. So the court wouldn't have allowed an MCA to lose their seats 6 months before the general election. That will be discrimination. So how the contradistinction or to distinguish will come in place is when the litigants will be arguing that the Wanjiku Kibe case was pegged on a general election. The Ndakwa case is pegged on a by-election. And that is why Ndakwa should not be sitting pretty if he goes before a fairly progressive judge. A progressive judge is to find merit or will find merit in any petitioner's argument that Ndakwa ought to have resigned within 7 days of his nomination as per the Elections Act and the IEBC directives that were given.
Maybe Wakili, you've given scenarios. If Ndakwa wins, what happens? And now, what if he loses after 27th November?
That is why I told you that whether he wins or loses, we are headed for a very fierce legal battle. If he wins, it can be a reason for challenging his election through an election petition that we voted for, or people of Malava elected an ineligible candidate who never resigned. Of course, Ndakwa will rush and rely on the Wanjiku Kibe case. And his opponents will argue that Wanjiku Kibe case was on the general election. His was a by-election. If Ndakwa loses this election, you can take it to the bank that the next week he will go for a small holiday in Mombasa and be back to walk into the county assembly and reclaim that seat of Kabras West. That someone will go to court to stop it, arguing that it is an illegality and that even though Ndakwa never resigned, it was the presumption of the law that once he was cleared by his party to run and he accepted to run and he ran, that seat naturally became vacant. And therefore people will be seeking to stop him from going back to the county assembly. On the other side, he would have lost in the National Assembly. It speaks to his chances, perhaps. If you are confident that you're going to win the Malava seat, Why then hold the MCA seat this other end by not resigning and struggle to become member for Malava constituency? He's trying to balance, and which balance may eat him up.
So do you think the law is mum or silent on that issue, on a by-election and on a general election?
The law is not silent. The law has spoken. The law has said that an MCA who wishes to contest must resign within 7 days of the nomination. And you've rightly quoted the statute. It is the Court of Appeal which said MCAs need not resign. In that Court of Appeal, an argument was put forth that since it was a general election, the Honorable Wanjiku Kibe had been elected to the County Assembly of Kiambu to serve for 5 years. And therefore, the Ndakwa case is not to be compared to the Wanjiku Kibe case because by-elections and general elections have different legal parameters within which they are held. So the law is not silent. It is people who are choosing to be silent on what the law provides.
But again, Wakili, if IBC has pronounced itself on this matter and it has given an advisory to Ndakwa, assuring him that he need not to resign under Elections Act 43(6), maybe how is the interpretation of law?
That is the IEBC. IEBC is a corporate person. It has given what we call an advisory opinion. The role of interpreting the Constitution is vested in the High Court. And IEBC's opinion, my friend, it is just like your opinion. Anything that you tell Ndakwa and what IEBC has told Ndakwa has the same legal weight. So IEBC is not a super interpreter. Even the Attorney General, who generally is the government lawyer number one, would advise government and the court would overturn that advice by the Attorney General. The Attorney General has lost cases severally, yet is the Kenya's finest legal mind in terms of appointments. The IEBC you are quoting has lost an election petition before the Supreme Court, the Raila Odinga case in 2017. IEBC lost. And it is IEBC that will be sued alongside Ndakwa. If Ndakwa goes to Parliament, National Assembly without resigning, whoever that goes to take that petition, Ndakwa will be the first respondent. IEBC will be the second respondent. The returning of Samalava will be the third respondent. If Ndakwa goes back to the County Assembly of Kakamega, IEBC will be the third respondent. The County Assembly will be the second respondent, and Ndakwa will be the first respondent. So IEBC is just giving its opinion. It is entitled to its opinion, and perhaps let Ndakwa rely on that opinion so that whichever way this election goes, we can test the opinion of the IEBC through a legal process.
43(6) under the Election Act say about this issue?
Oh, thank you very much. Thank you very much for that question. As an MCA seeking to vie for a bigger position, for example, MP or senator or governor or whichever elective post that is there, need not resign before contesting for that position. That is the position of Section 43 of the Political Parties Act, as you have said, as well as the courts. The Court of Appeal has clearly stated that in the case of Anne Kibe Wanjiku, who was an MCA and vied successfully for the seat at Gatundu North and won, that question arose. The question you have asked me arose, and the court interpreted Section 43 very well. At first, there was a misnomer, which is also existing in Kakamega right now, which is saying that Honorable David Ndakwa should have resigned before contesting for the Malava seat in the current by-election. I want to state categorically that my minority leader, Ndakwa, need not resign before he puts his try in that particular ring for the MP for Malava seat. And the position is because the High Court, in the case that you have just mentioned, had erred by saying that Honorable Anne Wanjiku Kibe ought to have resigned. However, the Court of Appeal cleared that, and it clearly stated that an MCA need not resign because, one, he is not a public officer. Our MCAs are state officers. If you look at Section 43, it obligates public officers to resign, but not state officers. And it goes clearly to exempt the kind of people who need not resign. He says the president does not need to resign to vie for a by-election in a position. The vice president, so the deputy president need not resign. A governor need not resign. An MP also need not resign. And an MCA should not resign. They are exempted from resigning. Why? The logic is very clear. These are people who are representing the electorate. Assuming that he resigns, who will be representing these people between that period of resignation and the election? They will actually be declared, they'll not be enjoying that representation within that period that is under resignation. And that's why the law exempted an MCA from resigning before he conducts another seat. Because one, that person, the people he represents will not actually be represented during that period that he has resigned and he's going for the elective position. So the resignation is not a must for Honorable Ndakwa. Honorable Ndakwa should actually proceed and get the try to that particular post. And we wish him well because he's a very diligent worker. He's a very steady man, very articulate, very good at in debate. When Ndakwa speaks in the House, you always know that everybody will sit and listen because he speaks to the point, he has content, and is a kind of people that if Malava choose wisely and get him that position, they'll actually not regret. He's a bright mind, and we need such people for higher offices. He's here at the assembly, he has been very good. But as you say, when a child grows and he goes for other greener pastures, you cannot say that let him remain with us. So here at the assembly, we wish him all the best. And we know Ndakwa is destined for great things. At the assembly, we have the minority wing has actually done changes whereby it has replaced him as the minority leader. So currently, on last week, the minority section sat, convened a duly convened meeting, and using standing order number 16, they were able to undergo all the procedures that are required to change leadership. They actually, the seat, they discussed and decided that Honorable Ndakwa be removed from the office as the minority leader. Not as an MCA, mark my word. He's still the MCA for Kabras West as we speak, until that time that he'll resign or take the next seat that is coming. However, at the assembly, the minority wing of our assembly sat and meticulously followed the law, replacing him with the Honorable Titus Kwoma, who is another very able MCA and very good man, to join us in the leadership as the leader of minority. And that decision, after it was done, it was duly communicated to me as the speaker via a letter from the whip of the minority, which was duly received. And that is in accordance with our standing orders. It was, they followed that procedure well, and we have read it in the House, declaring Honorable Titus Kwoma as the current minority leader at Kakamega County Assembly. And Ndakwa has now been replaced as the minority leader. But as we say, he is still the MCA for Kabras West. And that should be very clear, as earlier stated. We also have Honorable Sasita is now the current chief whip at Kakamega County Assembly. And I believe the two, having joined the leadership, which is also on the other side, the majority wing, we have Honorable Philip Maina, and who is actually doing everything well, and then Honorable Mangeni, who is the chief whip, Honorable Boganda, that is Mulama, who is the chief whip. With this kind of leadership, the assembly, we are seeing ourselves make various strides in our duty for representing the people of Kakamega and legislating as well as representation.
Maybe, Speaker, under based on this interpretation,
Yes.
it means Honorable Ndakwa will continue representing his people. Same applies to getting salary. Then, at what point does he cease to be an MCA?
The law is silent on that. The law is silent on that, and it will presume that he'll continue being the MCA until even at the time of swearing in as the MP. When he takes over the other seat, is when now he relinquishes the seat as the member of county assembly, because at no time does it say he should resign. And you know, our law is very clear. What the law does not prohibit, it is legal for it to be done. So as long as it has not exempted him from resigning, he ought not resign.
And the election outcomes, it is two-way. Either you lose or you win.
Yes.
What if he loses in this by-election? Then does it mean he'll come back to be an MCA or?
Yes. If he loses and he has not resigned by the time the election will be over, then we'll welcome him back. Not even welcome back, he'll continue with these duties, only that he'll not be the minority leader, but he'll continue representing his people of Kabras West, in case he loses. But as I said, we believe and trust that he'll put his right foot forward and ensure that he captures that seat. And we at the assembly shall be very, very happy with such an outcome.
Yes. Maybe as a custodian and as the head of legislative in county assembly, Kakamega County Assembly, maybe have you received any petition challenging his bid to vie for MP seat under this issue of resigning or not resigning?
I see that on the social media, there's a lot of being said on social media about Ndakwa has not resigned, Ndakwa is still earning a salary, but nobody has done any substantive petition to us. Or am I aware if anybody has gone to court? But he should be advised before he does that he stands a big chance of losing. Because if that has been declared at the highest court, that an MCA need not resign, why should he actually put such a petition? If somebody puts such a petition before the court, I can advise you for free that you is likely to lose. he has 95% chances of losing with a very small margin of winning. So better not waste your money petitioning to the court, because it will be, the law will be actually cited, and the section 43 of the Election Act will be cited, which is so clearly, and it exempted an MCA from resigning.
So about the issue that it was around, a word going around that he actually wrote a resignation letter and table before your table, and maybe you sat on it. Maybe can you maybe give us clarity on that?
No. As we say, I've not received any such letter. If he actually, if he received, if his conscience tells him to resign today and I get a letter tomorrow, I will actually gladly take it and declare that seat of Kabras West vacant, so that we can also have another by-election for Kabras West. But so far, we don't have such, I've not received such a letter. Those are just rumors. The only letter I received was from IEBC, which was actually clarifying the position that Honorable David Ndakwa need not resign for purposes of Section 43, unless for other purposes, that is okay. So if he resigns, I will let you know. But so far, he has not resigned, and therefore he's still an MCA representing the people of Kabras West.
Thank you, Mr. Speaker.
My question, I would really wanted to, I really want to know, and it is standoff and people, maybe for clarity, maybe you can help us understand. You're talking about majority, minority, and all that. It is something that is also affecting national politics, where now we have the broad-based government in Kakamega Assembly. Which are the minorities you're talking about, and which are the majorities? Because you're talking about the broad-based currently, but also from where you see it as a learned friend or a lawyer, how will you be able to advise us on who is majority and who is minority with the broad-based government?
Now, the issue of broad-based government has not been devolved back here in Kakamega. We hear that at the national side, but on my desk, the letter I have is the Kenya Gazette of 2022, August, which clearly shows that the majority, according to the voting patterns, in Kakamega is Azimio Party. Azimio Party is the majority coalition party that we have as per our standing orders. And Kenya Kwanza is the minority in Kakamega as we speak, and as per the document received on my desk. The issue of broad-based is at the national level. The documents there could have reached the Speaker of the National Assembly or the Senate. However, here at the Kakamega County Assembly, I've not received any document to show that there's changes in the party. And therefore, unless and until I receive such a document, minority is still Kenya Kwanza, and majority is still Azimio.
Okay, thank you so much.